and go to other law schools and sort of see what those law schools have to offer. By mooting, you actually have an opportunity to do that. For example, if you have a moot at the National Law School, Bangalore, if you have a moot at the Jodhpur NLU, if you have a moot in Jindal, in Symbiosis, you get to go there for a week. You get to understand how that law school, what's the atmosphere at the law school. And it actually is something that's beneficial because you can take those learnings and that perspective back to Mumbai and apply it into your daily life. Coming to the next slide, right? And MCA members, on this slide, I'd appreciate if I falter anywhere, please sort of correct me.
Got it, Karan. Will do.
Yeah. Now, the freshers moot is a very, very, very dumbed down version of a moot because its intention is to facilitate you or to encourage you to actually argue, right? So it makes life simpler for you. It says that, okay, you only need to argue from one side. You don't need to submit a memorial. You only need to argue for 6 minutes, right? So let's look at how the format works. One of you guys, like we have 90 people on this session. So each of you will be assigned one side, either the claimant, which is Titan Constructions, or the respondent. Now you have to prepare on the fact sheet on the basis of the side that you are allotted. Now, here's the catch. You get only 6 minutes to argue. I have been talking in front of you for the past 15 minutes. I didn't even realize. So just imagine how fast 6 minutes will go. So you need to be very clear on what you want to say and why you want to say it. You have to drop arguments that are irrelevant. You have to be very clear on what is something that I need to say to convince the judge to look my way. Now, the order that you'll follow in a round would be claimant goes first because claimant Titan Constructions is the one who's initiating the arbitration. Then you have respondent. So claimant for 6 minutes, claimant for 5 minutes, sorry, generally, respondent for 6 minutes, and then you have a rebuttal from the claimant to respond to whatever the respondent has said. Sir rebuttal is something that's generally not permitted, but it may be permitted basis the judge's discretion. And here I just like you to pay a little more attention to what the scoring parameters are. And this is something that you should do for the next modes that you do as well, right? Go through the rules, look at what you are going to be marked on. Because you guys have done entrances, you are very nitpicky about marks. So please look at what the bifurcation is. First, understanding of law and procedure. Question to you. What is the law you're dealing with? And what is the procedural law you're dealing with? Take a minute to just think. To my understanding, the law that you're dealing with in this Moot proposition is the Contract Act, perhaps, maybe basically contractual claims, and you're dealing with the Arbitration Act. So you need to be thorough with what those legislations say and how that applies to your case. Application of facts is the next parameter. Let me take a minute here to just drill this point into you that the facts are something that you can't go wrong on because all 90 participants in this session are offered the same fact sheet. Everybody gets the same opportunity to argue. You get the same sort of briefing. Basis those facts, the way you apply the law to it is what the subjective element is. But what remains is that the facts are the same for everyone. So you can't have a situation where your opposing counsel knows something in the facts which you don't know. That is the primary requirement for a moot. You need to know your facts. Now, going forward, the ability to answer questions is something that is sort of a controversial, not a controversial, but something that's a very subjective element, right? Because you may get a bench which does not ask you any questions. On the flip side, you may get a bench which asks you questions every 10 seconds. You are completely derailed of what your submissions were. You're actually just engaging in a conversation. Now, be prepared for either of these scenarios. And with that understanding, you need to approach your submissions. Now, style, poise, courtesy, demeanor, and organization and flow of arguments. We'll come to organization and structure, but this demeanor is something that will not come off the bat. It comes from with practice. It comes every successive time that you argue, right? So don't try to get your style in order right now. Try to make your submissions clearly and observe and emulate people, and then you will obviously develop your own style as you go forward. Okay. Now, this is the round progression of how the freshers would move. You will have your prelim rounds where you argue for one side. Then you'll have your semifinal rounds where I think the top 20-ish would qualify. Then you argue for the same side there, and then you have the final rounds. Okay. Now, one element here, there may be instances where one of you may have to argue alone. That's called arguing ex parte. What that means is you don't have your opposing counsel to argue, you're just making your own submission to the judge, and there's nobody else to oppose you. Don't consider that to be a negative aspect in any way. That's just a requirement for this moot because you don't have even pairings all the time. So be aware that you might be arguing ex parte and then go with that preparation, right? Moving to the next slide. Now, I don't know when you guys got the fact sheet, maybe 1.5 weeks prior to the moot, so about a week prior to this. Where do you start? You start with the fact sheet. You read the fact sheet once. Then you read it again. And I'm not joking. You read the fact sheet again. Then you look at who the parties are. Now, in your fact sheet, MCA has done a very clever thing. They have not specified who the parties are in the cause title. So when you approach a court order, judgment, or even a pleading, you'll have a cause title where it says that, okay, this guy is the claimant versus this guy is the respondent. In this case, you don't have it. So first, identify that. I've already mentioned that in the session, but just identify that. Then you look at what are the relevant, so you look at the authority that's presiding, right? So in this case, is it a court? Is it the High Court? Is it the Supreme Court? No, it's not. Is it an arbitration tribunal? No, it's not. It's a sole arbitrator. The sole arbitrator is a retired judge. Okay. Now, look at what the issues which have been extracted and specified towards the end of the fact sheet are. There are two issues, right? Both of them are substantive issues, if I'm not wrong. Then, and here's where it gets interesting. You take those issues, you take who the parties are, you take a red pen and a blue pen, or you take, if you have an iPad, you take a red marker and a blue marker, or you have, just take whatever you want. And you mark up the fact sheet. Red for respondent, blue for claimant. And you mark out each paragraph. What is something that one side can use? What is the other thing that the other side can use? So that at the end, after this exercise is done, you have the fact sheet and you know, okay, if I'm arguing for respondent, I have to look at this paragraph. If I'm arguing for claimant, I have to look at this paragraph. And this is actually a very crucial step. And believe me, this is something that was recommended to us by a senior counsel at the Bombay High Court. So this is something that people actually do. And even judges do this, for example. They have those pencils, which is red on one side and blue on the other side, and they mark up their briefs that way. Now, what is the applicable law for this Thresher's Moot? Without going into detail and without MCA cursing me for this, applicable law is the Contract Act, and you are approaching this under the Arbitration Act. That's all. Read the Contract Act. Read what are the relevant sections for this. Read the contract. Look at the clauses in the contract. What is actually at issue here? And then also look at the Arbitration Act to know what you are even doing. Okay, this is an arbitration. Where has the initiation for arbitration been invoked, under which section? How is the arbitration agreement framed? Is it a valid arbitration agreement? All these questions need to be something that you need to answer, right? Now, moving forward with this understanding, we come to how do you go about the very terrifying task of researching, right? Vani, can we go to the next slide? Right. Now, on research, I would suggest that you start out with web searches, right? You start out with web searches and you look at a lighter version of a textbook. For example, if you have a legislation that you're dealing with, you look at a lighter version, not a commentary, but just to get an understanding of how the sections operate, what is the relevant section, you'll do that from a Google search or anything. Now, once you have that, you go forward and you identify publications made by law firms, lawyers, scholars who have written on the subject. By doing this, you will be able to identify what are the pivotal cases, what are the pivotal sections, what are the pivotal propositions in that issue that you need to go deeper into. Once you have those publications, you will find case laws cited in those publications. Then you track those case laws down into on your legal research databases. That will be SEC, that will be Manupatra, that will be Indian Kanun. So even the High Court and Supreme Court websites, you'll get that judgment out. Then you read the judgment, you see what the ratio is. Okay, then you've understood, okay, this is the position of law as on date. How do I go further? How do I apply this to my understanding, so to my facts at hand, and then you develop your submission, right? Now, one point here, it is the reality that people are using AI in the legal field and also in sort of practice. So lawyers are using AI, law firms are using AI. You need to be smart about it. You can't, under any circumstance, in any situation in law school, take an AI response and use it. You need to use AI smartly to identify specific questions and get help on those specific questions. For instance, the way I would use perhaps a Gemini or a Claude is that if I know that I'm dealing with a securities related sort of question and I want to get a source, I want to get the 1954 SCR bill. So I'll ask Gemini to specifically extract that bill for me and give me a reference. That is a permitted and an advantageous use of AI. What is a completely discouraged use of AI? Giving the fact sheet to AI, asking it to give me submissions, and copying the submissions and arguing in the rounds. You will be not just marked down, you will be called out for it, and you will be told that this is not anything, and you will realize that you don't know the law. You've just relied on somebody else's understanding, which is the AI's understanding. So it's pertinent for you to read up the law, use AI smartly, and then sort of prepare. Can I take a minute here to just see if there are any questions before moving forward? And I understand this might be a little heavy, so please let me know.
Nothing in the chat box, Karan. I think we can go ahead. Okay,
All right.
someone just Miss Vidula Barze has posed a question, I think.
I just have a question. You said that, since you only have 6 minutes, you're supposed to drop certain arguments. Like, how do you decide which arguments to pick? How do you decide which arguments to drop? And I have another question. You said something about rebuttals and sur rebuttals. Would you please elaborate on how exactly rebuttals and sur rebuttals go?
Okay, fantastic. Now, when you're preparing for this and you're preparing for the claimant, for perhaps, you will, during your preparation, come up with 6 arguments that you want to make. Now, you will be very, very, very conscious of the fact that since you have 6 minutes to argue, you can't make those 6 arguments. And you are not geniuses off the bat to identify, okay, this is an argument that I can skip. This is not that important. You will not know that. So it is the process of trial and error. In your prelim rounds, you're prepared on 6 arguments, you try to make a few, and then you realize that, okay, this one's not working. This is actually working. This is convincing to a judge. Through that process, you eliminate and drop out arguments which present your case in a weak manner. And while doing that, you identify the arguments that are actually more beneficial to you and the opposing counsel cannot rebut. Right? Now, coming to the second question that Vidula had with respect to rejoinders. The way rejoinders works is one party argues first, the claimant argues first, respondent responds in a way to whatever the claimant has argued. For example, claimant makes submissions A, B, C. Respondent may have prepared E, F, G, but it tries as much as possible to also respond to A, B, C. Then claimant is given a reserved amount of time to respond to what the respondent has said. So you take one submission of the respondent that you want to sort of combat and you make that out. And then if the judge wants, they permit the respondent to also come back and rejoin. I hope that clarifies. Now I have noticed that a couple of questions have come. Can we start with Sejal? Hi Sejal. Can you let us know your question?
Yes. So you talked about there's just one party and there's no respondent or claimant to it. That's ex parte, right? So would you elaborate on it, that how
Right.
it actually works in court and then how we have to argue, if that's
Perfect. Thank you. Well, I realize that I didn't spend a lot of time on that and it's really important. So first, understand why this happens, right? Don't look at the court. Let's assume this is happening in the freshers mode. Why would this happen? Maybe you have an odd number of participants in a court too. One party will have to argue alone. So the claimant may have to present its case without being responded to by the respondent. In doing that, the claimant has to stick to its natural submissions. That I'm the claimant, I'm initiating this arbitration, I want so and so, these are my reliefs. You say what you want. It's little more sort of interesting for the respondent because you don't have somebody who's already made submissions that you need to come back to. So the respondent naturally would also have prepared a set of submissions already. The respondent makes that. There are no rebuttals, there's nobody else opposing you. You make your submission. So in a way, it's actually an easier environment because you don't have to track the other submissions. You just have to say what you want to say. But be sure that the judges are conscious that there's nobody sort of opposing you. So they'll put on that hat. They'll put on the hat of the opponent and they'll sort of ask you questions, right? So in essence, ex parte means where when one of the participants will have to argue by themselves and they won't have an opposing sort of participant on the other end, right? I hope that answers your question. Khushi, how are we supposed to address the arbitrator? Okay, fantastic. I'll prepare this for a little later, but we can address it, right? Now, considering that this is an arbitration, you use two. Actually, we should go to that slide. Vani, can you perhaps? Oh yeah, perfect. This one. Right. Look at the first box on the top, right? In the freshers moot, you have an arbitration sort of system where you have one sole arbitrator who's a retired judge. So, and the MCA may come step in here, but it may be acceptable for you to use Mr. Arbitrator or Miss Arbitrator, depending on what the gender of the presiding arbitrator is. And secondly, you can also use your lordship or your ladyship or my lord, because in fact, that arbitrator is a retired judge, right? So you can use that as well. This should be acceptable. Moving to Lai's question. How do I know if a judgment applies to my case? Can I only use a judgment if the facts of the judgment are the same as the moot problem? Not really. More often than not, you will not find a judgment which is squarely applicable to your facts. What you do is you look at what is the point you're trying to make. For instance, in this case, I want to make X point. I want to say that I don't want to go into the facts, but if you want to say something like uh, the contract was terminated invalidly. Now, for that, you look at what are the relevant legal authorities for this Contract Act, your contract, and case law. Once you've read up everything, then you see how can you sort of harness the observations of the court in these authorities and bring them back to your case. In that, what is important is you look at what is the ratio of the court. You don't look at arbiter because all across the facts in case law and authorities may be different, but the underlying legal ruling or rationale will be a common thread, right? Because that's how law develops. So you pick up on that legal proposition and then you apply that to your facts. Okay. Sia says, as a respondent, do I need to counter the arguments of the claimant at the very beginning or at the end? I would suggest you adopt an approach which is a mix of both. You, while arguing for the respondent, you can say that my learned friend on the other side or the opposing counsel for the claimant has argued X, Y, Z. To that, it is my submission that ABC. So while making the submissions as a respondent, you need to be mindful of sort of mirroring the submissions, what the claimant has said, and trying to combat those in the middle of your argument. Advisably, don't sort of leave it towards the end because you may not get time. And if you have a very valid rebuttal, don't hold on to it till the end, right? Make that off the bat, say it at the start, and proceed with your submissions. Couple more questions. How to use AI smartly? Elaborate only for legal research. I think I have elaborated enough. And this is something that's very subjective. So you might have to sort of identify this by yourself. Yes, Tanvi.
I would just like to add for everyone in this opening address that Karan has given us, it says name, but I just want to clarify you can't reveal your name through the duration of the competition. You'll be allotted a speaker code and you have to address yourself with the speaker code. So even when introducing, please use that. So it would probably be something as C1, CR2. So claimant 1 from CR2 or something on those lines.
That's it. Good catch. Sorry for that. So just to repeat, no disclosure of your name, you would say, I am C1 and I represent so and so, right?
Can I also add something, please?
Yes, of course, Vidura.
Yeah, I'm just saying for the question of how to address the bench, it would be in your favor if you ask the bench beforehand as to how they would like to be addressed. You can simply ask them if the bench is okay with it. I would address the bench as Mr. or Mrs. Arbitrator or your lordships. So they will likely tell you what they prefer to be addressed as. That's it. Thank you, Karan. Thanks, Tanvi.
Perfect. Another question. Can you please elaborate on Sir rebuttal and why a respondent is not allowed to do that? Okay, very simple, right? In the rules, if you go through it again, you will find that the rules provide that the claimant is entitled to reserve time for a rebuttal. Why is this the case? Because claimant is the first person to speak in the round. The respondent is the second person to speak in the round. So it is assumed, or rather it is expected, that the respondent responds or rebuts to whatever the claimant has argued when it has the chance. Now, claimant has not got a chance to respond to what the respondent is saying. Therefore, it is the last speaker in the room which gets a reserved time as rebuttal. That is why generally you don't have a Sir rebuttal, because then the loop would just infinitely continue, right? That claimant went first, respondent went second, claimant responded in rebuttal, and then again respondent has come up. To avoid this loop, it is generally the norm that claimant gets a rebuttal, respondent does not get a rebuttal. It has nothing further to that. It's just the fact that you already have an opportunity to respond to the claimant, therefore you don't need a Sir rebuttal or a Sir rejoinder. Okay, fantastic. This is great sort of interaction. I appreciate this a lot. Now, let's just go through this slide again to see if we've missed out anything. We've covered how you're going to address the bench in the freshers moot in the first box on your slide. Now, let that go away. Let's look at the other three boxes, because I'm assuming that you may want to refer to this session or refer to the learnings of this session in the other moots that you appear as well. In Indian law moot courts, right? Generally, it will be the presiding authority would be a court or a tribunal. In that case, it is acceptable for you to say, Your Lordship, Your Ladyship, My Lord, My Lady. That's how you address the bench. In an arbitration, where it's a panel of arbitrators, for example, there are three arbitrators, acceptable to address individual arbitrators as Miss Arbitrator or Mr. Arbitrator, and collectively as members of the tribunal or this tribunal. Now, in international law, and you might be doing the international law grand moot this year. So, in international law, each of these judges, for example, in the ICJ, are addressed as Your Excellencies. So that is the distinction for public international law moots. Indian law moots, Your Lordship, Your Ladyship, arbitrators, Mr. Arbitrator, and international law, Your Excellencies. Now, how do you respond to your opposing counsel? Sorry, I said the answer. How do you respond to the other side who's arguing with you? You don't say that, okay, the name of the person has said this. You address them, and this is something that's followed in courts as well. You address the other side as my learned friend. My learned friend contends that so and so is the case. Or you say that the opposing counsel has submitted X, Y, Z. To that, it is our submission that ABC. Right? This should be a way to sort of start out. And now, focusing a little bit of time on the opening of your submissions. This is important because it is the first moment that you utter a word in the round, and that is where you set an impression to the judge. And first impressions do last. So it would serve you well to use the template that I have put on screen with the suggestion that the change that Tanvi has mentioned for your submissions as well. So you say, Mr. Arbitrator, good morning. I am C1 and I represent Titan Constructions, the claimant in this arbitration. Then you say that, give a factual overview that the dispute has arisen out of a joint development agreement entered into by so and so. Accordingly, I'll make two submissions. And you first set out your first submission. Then you mention your second submission. Then you come to your main arguments. Now, this structure is not just important, it is a mandatory requirement in mooting. Okay, it's an unsaid rule that you have to sort of give out a roadmap, do some signposting of what you're going to submit before you say it. So, two legal sort of research and oral arguments rules that you can use. First, to approach an oral argument, you first say what you want to say, then you say it and then you say what you have said. So you give an introduction, then you make your main submissions, and then you conclude. And this might sound as a repetition, and it may sound redundant, but this is actually the expectation from a moot court participant. And the second is something called as an IRAC method. Let me just type this in the chat. IRAC. Somebody from the MCA just expand on this later, like in the chat box. IRAC stands for issue, rule, analysis, conclusion. Issue, right? Issue deals with what is the question that you want to answer. Rule is what is the applicable rule of law that is applicable to the case at hand. Analysis is the application of facts to the rule. And conclusion is what is your submission, right? Straightforward. You may not have to sort of bring this out in your oral submissions, but this is a great starter and a great way to structure your research, right? You set out your question, you get the law right, you get the facts right, and then you get your answer. Now, moving forward. Vani, next slide, please. Okay, come back. Sorry, come back. Fantastic. Now, I'm aware that we have sort of spoken all in the air. So I would prefer if we spend a couple of minutes to look at live examples of how arguments take place. The first example that we look at is an argument before the Supreme Court, before the constitutional bench in the modification of arbitral awards case by Mr. Arvind Datar. That will give you a perspective of how Indian law moot court competitions expect you to argue. The second example that we'll see is the Philip C. Jessup last year's 2025 rounds from Miss Erica V. So let's have a look at this and then we'll sort of crystallize what we learned from these submissions. Vani, can you help us with presenting Mr. Datar first?
Yes, Karan, just a minute.
Yeah.
I hope my screen is visible.
Yep.
Got it.
Also,
Sorry, I don't think we can hear. Can you go a couple of seconds piche? Yeah, play from here. Go on, let it play.
shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Now, my submission is 2A is itself a recognition that 34 on a standalone basis will not suffice. For domestic arbitrations, they require some element of judicial restraint, and Parliament has provided patent illegality appearing on the face of the award. So illegality must be patent, it should not be latent. And the further proviso says you can't set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. Now, under section 34 as it stands, can we read in an inherent power to modify the award? And as all lordships have remarked, the larger power always includes the lesser power. Since Xavier's judgment is there, I can give the para number. Lordship may also note Pepsi Foods where they say the larger
Right,
power
we can
includes
stop
the
here.
smaller power. Please see my note now.
Perfect. Now, just take a moment to think of this, and then Vani, can you present the second one as well?
Oh, yes, Karan.
To hear the claim. And so I turned first to this court's temporal jurisdiction. On this point, Judge Gomez Robledo had queried agent for the applicant as to when exactly the dispute between the parties arrives. Agent for the applicant proffered the date the 6th of May, 2024, and we agree, we don't intend to contest that particular fact. But the question the agent for the applicant must answer is whether ultimately the dispute arises out of facts or situations that occurred prior to the entry into force of the clause, not the dispute itself. And this is a function of the language of the compromissory clause and the function that these temporal restrictions were meant to serve. These
Perfect.
clauses are
Thank
what
you, Vani. I
are
think this should be it.
double exclusion clauses.
Okay, thank you so much. Now, let's just take a moment to first appreciate that these two are very, very, very divergent argument styles, right? Mr. Datar is appearing before the Supreme Court at Delhi in India, and he's coming from a sense of stature where he's an authority in law, right? So he has that confidence, he has that composure, and he can address the court that way. Erica V is appearing before the Philip C. Jessup final rounds. She is a student and she's appearing in an international law moot. What you are expected to do is something which is a combination of these two, right? Especially for the freshers and the Indian moots that you do. Some traits that you'll have to sort of think about is composure and the pace at which you argue. Now, these two go hand in hand. When you slow down the speed at which you're arguing, your composure automatically is inherent in your arguments itself because you're not rushing, you're thinking of what you're saying, and then you're slowing down. While also doing that, you have to be mindful of the volume at which you argue. You are not too loud, where you're trying to be very aggressive, but you're also not very subservient, where the point may not come across. So that voice modulation, sort of that code craft will come up as you go on in practice. Now, you may recollect that we showed the scoring pattern or the scoring criteria that we have. Couple of points in that scoring criteria are the code craft, demeanor, poise, style, courtesy that you use, and two, the structure that you use. So bear that in mind. Now coming to the last slide that we have. And this is sort of my hot take on how to moot. First, and this will be evident from what you have seen in the two videos that were played as well. In essence, mooting is not an extempore activity where you're supposed to sort of give out a speech. You are going to be interrupted. It is a conversation where you persuade the judge. And to consider it to be a conversation is very important because it sort of brings down the nerves. In the end, what are you doing? Let's assume that you are just in an informal setting. You are trying to speak in a very conversant manner to a senior, and you're trying to make that senior see it through your viewpoint. Now, bring that back to the mooting scenario. It's just a formal setup where you're wearing a tie, where you're wearing a blazer, or as a basically you're just in a formal attire and you're arguing before somebody, trying to have a conversation and make them see things your way. Now, the second sort of view that I have is on courtroom etiquette. You have to be mindful that since this is not a completely informal setup, there are certain rules in terms of addressing the court that you need to rely on. I don't want to go into this into detail, so you may want to refer to the sort of guide that MCA has provided. It might be a great starting point. Thirdly, and this is very, very, very crucial, you might not get the chance to do this in the freshers moot, but going forward, please discuss everything in the moot proposition with your team. And when I mean discuss, you take a printout and you discuss every line. If you have to, you read the moot proposition start to end with your team. You get their perspectives, you get what is one way of looking at something, what is the other way of looking at something. By doing this, you will sort of identify every perspective to the moot proposition, and that will help you have the foresight to argue in the round, right? We call this in law firms and in legal practice stress testing a proposition or stress testing an approach, where you try to drill that argument down, you try to break it down to its bare essence and see if it still holds. So that can be a great tactic. While doing that, let me just mention that I am currently preparing for a moot court competition as well. And this is my moot proposition, right? What I'm trying to say is the facts are key and you need to be aware of it in detail. And I can't stress this enough. That's, as I said, that's the only thing that's uniform across everybody. This is a 60-page moot proposition. You will be given a 60-page moot proposition when you enter a larger scale moot, and you need to be aware of everything. Now, fourth, judges will ask you questions. Those questions may at times feel hostile. The judge may be aggressive, but you need to be aware that the judge is not your enemy. The bench is not making a personal attack on you. The bench is rather giving you an opportunity to one, clarify your point, two, double down on what your submission is, and three, to drive it home, right? If your question is something that you already knew of, in cricketing terms, it's a juicy half volley that you have to drive to the boundary. If it is something that you've not prepared of, or it's something that's weak in your submissions, you duck. It's a bouncer, or you let it go. But basically, think of questions as something that are opportunities for you to develop your argument further. Now, the MCA guide will have a question or a point on what do you do if you don't know the answer to a question that a judge has posed. The guide may say one thing. I have a little different take. I would say that you can approach what point number 5 here, use the approach at what point number 5 here says. If you don't know the answer, you accept, but you don't accept, I don't know this answer. You say, I'm unable to assist this tribunal or unable to assist this court on this at this moment. Please allow me to get back, and you proceed with your submissions. You don't admit that you have not read up. You don't admit that you don't know shit. You don't plead your ignorance because you are not ignorant. You are a lawyer, for God's sakes. You say that I'm unable to assist. Let me allow me to get back to you, right? And that's exactly what happens in court as well. Just to clear the cloud from here. In court, there are several times where the lawyer appearing or the counsel appearing does not know the answer to what the judge has asked. The counsel does not say that I don't know. The counsel says, let me get back. I'll check on this point. So that's an approach that you can take forward. Now, again, you have 6 minutes to argue. In 6 minutes, you have to introduce yourself. You have to tell what your case is. You have to then make your case, and then you have to conclude your case. You have to respond to other people. So be aware that within those 6 minutes, you have so much to do. It's impossible for you to make every point that you have written down on your sheet of paper, which are your notes that you're referring to. My advice would be prepare every point, try to argue every point. If something does not get argued within the limited time that you have, let that go. But be prepared on everything. Don't drop arguments right off the bat. Prepare everything, and let's see how the how the round sort of goes forward. Do you have to get back to the judge with the answer at some point of time? Technically, yes. Because if the judge has asked you a question which is on the fact sheet and you don't know, technically, yes. But in practice, it rarely happens that the judge comes after the round and like, bro, like, what's the answer to this? It doesn't happen. But it's advisable that if you don't know the answer, for example, there may be a case where I just forget what I want to say. For example, the judge asks me, okay, tell me which para of the fact sheet deals with this. I don't know at that point of time, but I can check and get back. So when I get the next opportunity to speak, I can clarify that this tribunal had inquired or asked me this. This is the answer. If you don't know, stay silent. Right? Can't you refer? Fantastic. Yes, you can. If you have the foresight to refer to the fact sheet at that point of time, great. But if you can't identify that, instead of spending 1 minute, 2 minutes, just rushing through your papers and trying to identify it, just say that you will get back. Because, Dharini, if you think of this, right, more often than not, if somebody asks you a question, even in day-to-day life, and it does not click to you in the first 2-3 seconds, most likely it's not going to come to you in the next minute as well. You'll have to really think to get it, but it might not come to you. So it's advisable to just say you'll get back at a later stage, and then look at your papers, look at your notes, and then come back later on. Okay, fantastic. We've covered time management as well. Anticipation. So what the word anticipation, what point number 7 here is trying to indicate to you is that when you're stress testing every argument, you know the weak points in your argument, right? So you are aware of what is something that the opposing counsel will attack and what the judge may pick up on. So be aware, be cognizant, be very conscious of what are the weak points in your argument and also what are the strengths. Try to highlight your strengths but don't deny your weakness. Just try to, in a very nuanced, a very subtle way, try to say that, okay, this is a weakness, but there are certain strengths that we want to look at more as well. Now, finally, the judges will ask you questions at any point of time. They may ask you questions in the first minute when you're submitting, and also towards the end. It is imperative that you answer that question at that point of time and then move on. Just avoid saying that I will address this later, or I was coming to this, I'm going to address this later in my submissions. If a question comes up, and take the time and answer it at that point of time itself. I think that sort of concludes what I have prepared on. Can we come to the final slide? Fantastic. Two takeaways at the end. First is, just remember that every college senior and every advocate who has mooted that you look at right now has been in the same position as you right now, right? They were there. Me, my team, my friends, everybody, all of my batch was in the position that you were in 2022. So we've been through this. We know the nerves, and it gets better, trust me. Second, Professor Daswani, who teaches at GLC, told me this during my freshers moot, that avoid indulging in pleasantries. Don't ask for a lot of permission. You have 6 minutes. Get to the point. Fantastic. Just get to the point, right? So that's pretty much everything from my end, from my preparation. Any more questions, I'll be happy to answer.
Hello, I had a question.
Yeah, please.
When we say that we don't exchange in pleasantries, we mean to say the first introduction that we make, is it?
No, that you'll have to make. What I mean is, you don't beg for permission at every stage that, may I proceed to the next submission? Are your lordship satisfied with this submission? Don't do that. Try to be aware of the fact that you are running short on time and make the submission, right?
All
Stick
right,
to what,
thank you.
yeah. Ajinkya's question in the chat box is, would the respondent also be expected to give a synopsis of the facts? The simple answer is no, you're not expected. But the answer that will help you distinguish yourself from the rest is that the claimant has started out in the round. It has given its narrative about what the issues are and what you need to look at. If the respondent just agrees to what the narrative is and then just makes legal submissions, that may be one approach, but my suggestion would be that try to set the respondent's narrative as well. That narrative will only come up when you, in very brief, tell the judge what is your approach to the fact sheet, right? And if you do that, don't look at this as a hard and fast tool that I have to narrate the summary of facts, which is one para long. I have to say this, then I'll move on. Think of it as a very fluid sort of argument where you specify or don't specify. You sort of make the point that, okay, this is what the claimant has done wrong. This is where the claimant has faltered. And this is why you should look at my argument instead. GM3, after I get to know if I'm the petitioner or respondent, how much time do we get to research the matter? MCA, can you take this up? When do they get to know and how much time do they get?
Right. So the allotments with respect to your sites have already been sent to all the participants. And kindly note that these allotments are with respect to all rounds of the competition, that is the preliminary, semi-final rounds, and the final rounds of arguments. So with respect to the time given for preparation, after the semi-final round is concluded, you will get around 1 or 2 hours to prepare for the final round of arguments, I guess. I hope this addresses the question that was posed.
If you can give them a date, like just to clarify, when would they get to know their sides approximately?
The sides have already been allotted
Oh,
to them,
fantastic.
Karan.
Great.
Right.
Okay. So you know the sides already, you research. Makes sense. Where will we? Okay. When can we make our prayers towards judges as a play due to claimant's opening statement for time, standard of language which we need to keep common or official language Okay, answering your second question first. There's no official language, but there's something called as the most ideal way to approach, right? For that, refer to the MCA guide that's given to you. That has sort of situation specific responses. What do you say at this situation? What do you say at another situation? So refer to that. You must have gotten an email about it. I didn't quite understand the first question that you've made, Samsung SM8266B. So I don't mind if you unmute and let me know your question. Meanwhile, I'll proceed to the next. Maybe not. Please go ahead. Sorry.
When we make our prayers as a plaintiff during our opening statement or rebuttal time.
Okay. Prayers have to be made towards the end, because once you finish your submission, if you have time, you sort of clarify your prayers. But practical matter, you may not get time to sort of specify your prayers. So prepare what you want. What relief do you want? What are your prayers? Have them written down, keep them ready. But unless a judge sort of asks you, may not be advisable to sort of bring that up, right? Because it will take time out of your main submissions. And that's just my perspective. Maybe a different approach that you can follow as well. Right. Bhagyashree Naik, maybe not before this upcoming competition, but in time, can MCA share with us a sample moot or submission already done in the past? Great question. The MCA is very proactive. They have several sort of demo modes, several recordings of rounds. Everything is available on the website. Please go and watch. It will increase the viewer count as well, so that will help us as well. So please, it's there on the website. And Sagar put the website YouTube link in the chat as well, now, for their benefit. Fantastic. Chavi, what is the ideal time reserved for rebuttals? For this, I would suggest 1 minute. So a claimant may go for 5 minutes submissions, 1 minute rebuttals. That should be appropriate, because you don't need 2 minutes for rebuttals, and that will just cut down on the time that you take to make your main submissions. So 5 + 1 should be great. If I'm not able to conclude due to lack of time, could I ask for extra time? Yes, Sia, that's a great question. Yes, you can. The way you do this is, as soon as you know that you're running short on time, or coming towards the end of your time, or the time has elapsed, you say that, may I request this tribunal, may I request Mr. Arbitrator to grant me or permit me an extension for a minute to either conclude your submission or to make another submission. Right?
What is the matter?
What is the matter? I don't know. Anyway. Saket Nabar. How different is the preparation for claimant and the respondent? How does the perspective differ for both of them, since one starts off his own argument and the other has time to respond? Preparation is not that different, right? You are dealing with different issues, your approach is different, but the preparation, like for instance, the steps that I have told you to follow to prepare, that will not change. Your arguments will change, and your approach to the fact sheet from a very sort of layperson view of what do you want in this moot will change. But the steps that you have to follow in terms of preparation will not change. How does the perspective differ with respect to time? Obviously, respondent has 5 minutes to listen to claimant submissions and then counter. So that's something that's there. But I think that drill does not matter that much. Sai, in opening of the first two submissions, do we need to explain issues or to put your facts to entertain issue? I think I've covered this. What you need to do is give an overarching structure of what you're going to say, specify what your submissions are going to be, make those submissions, and towards the end, conclude on your submissions. Anand Govind, since claimant can reserve 2 minutes for rebuttal, so does it mean that claimant first present for 4 minutes and then 2 minutes in the last for rebuttal, or can present for 6 minutes? No, it means that claimant gets 6 minutes, respondent gets 6 minutes. Claimant can reserve 4 for its main submission, and the 2 minutes will be sort of used to rebut after the respondent has made his submissions. So it's not 6 + 2, it's 4 + 2, right? The judge has equal access to the fact sheet. Yes, the judge will have the fact sheet. How do we state our prayers in oral submissions? Good one. There are some ways in which you are sort of advised by several people to make your prayers, which is a very formal way of stating your prayers. Personally, I wouldn't recommend that. I would just suggest that if it ever comes to the point where you have to narrate your prayers, you say that the relief that we seek before this tribunal is A and B. So A and B here will be the yes or no answer to what the issue is. For example, if your issue is Karan entitled to his right under Article 19, your prayer would be yes for a declaration that Karan is entitled to its right under Article 19. Ishita, should the claimants be asking the arbitrators if they need a summary of facts or just start off summarizing them? Again, Ishita, it's not that hard and fast of a rule, right? Don't approach this as you are required to make a summary. I would suggest just give a 1 or 2 line overview of what has led to this dispute. And that is important because one, it shows the arbitrators that you've read the facts and you're not afraid of telling them. And second, it allows you to paint a narrative of what is your side to the story. So don't think of this as I need to prepare a summary and then make it. Just think of it as I should be saying this to make my point across better. Pranav, are any teammates allotted? And in case they are allotted, how will we get to know about it? For the freshers mode, you don't have teammates allotted. Later on in your next year that you are moot, you will have grand modes in which you will have teammates. For the freshers, there's no teammate. Jyoti, in normal moods, when we refer to a case law, we point it out in the compendium. In freshers mode, if we have to refer to any case law, how do we point it out to the judge? Great point. You are advised, or it's preferable if you can have a printout, have 2 copies of printouts or 3 copies of printouts of the case law that you're going to rely on. First would be a copy for yourself. Second would be a copy for the judge, and the third would be a copy for the the opposing side. So any case law that you rely on, or even if you rely on any section, have the copy of the case law or that section with you when you're arguing. Don't argue without it. DC, is it possible to hold one practical moot session apart from this for freshers where you can show how it practically? Yes, I don't think there's another demo mode scheduled for this, but we have had demo modes in the past. Sagar has mentioned specified the YouTube link for the MCA website, sorry, YouTube channel at timestamp 1308. So DC, you can refer to that YouTube channel and there'll be recordings available. PDF मिल सकती है क्या class के बाद? Yes, I would suggest MCA if you want, you can share a copy of the presentation. Okay, I think we are through with the questions and we've sort of run out of time as well. So yeah, that's pretty much it.
Thank you so much, Karan. On behalf of the Moot Court Association, I would like to thank Mr. Karan Nair for conducting this workshop. I wish all the participants all the best for the Freshers Moot Court competition. Thank you, and everyone may proceed to leave the meeting.
I had a question.
Sure.
In the freshers, in the guidelines, it's written that submitting a memorandum or a compendium, a memorial or a compendium is not mandatory. So how do we evaluate if we should or shouldn't?
Okay, my take is 1, if you have time, prepare it. 2, if you think you're going to rely on something while making your submissions, for example, you want to tell the arbitrator, please look at this, and then make your submissions, prepare it. It's not a requirement for the internal GLC modes. Okay, so subjective, it's about how you want to sort of present your argument. How to prepare written draft, which is to be presented before the court. You don't have to prepare a written draft, you just have to make notes on what your submissions are going to be, and then you make those arguments.
In case of wanting to tell a judge that this is what I'm referring to, so a mere Xerox copy of it will do, right? We don't need to make a compendium for it.
That works. A copy of your judgment works. Since the prelim round is online, do we screen share if we need to make a point? Good question. I think MCA will allow you the flexibility to screen share, but I would advise against it because again, you have 6 minutes. In those 6 minutes, if you're sort of highlighting a case law on screen, You will have to screen share, go to that, ask the judges if they can see the screen. That takes a lot of time out of your submission. So I would advise against it, but you are absolutely entitled to do it.
Just to add on, in case any participant wants to share their screen to sort of present anything to the bench, kindly make sure that there is no breach of anonymity, any mention of your name or anything of that sort is struck off or not visible. Thank you.
Perfect. Okay, Vani, Sagar, MCA team, I'll take your leave. Thank you so much. Thank you.
Thank you, Karan, and thank you, participants. You may proceed to leave the meeting.
Hello.
Sagar, just a
Well,
moment. I think this is still being live streamed on